Hello there. And again, we're using a new program here, Global Meet. So bear with us. The whole idea here is that you get as much information as we can during this changing times in immigration. As you know, many of you have been in the world of immigration now for a little while, and it's amazing as I look back to the filings. Actually, the filings that we did last year, particularly for the H-1B, were already very well documented. And I look back at the ones that we filed 3 or 4 years ago, and which were well documented and under the law and the regulations that were thoroughly approved under the new interpretations that we're seeing today. Those cases like it would not be approved. So there's a lot of changes that we're making and strategies that we're applying to make sure that we do the best we can to make this filing season very successful. So let me just kind of recap what we're going to be talking about. So H-1B basics and application timelines. Timelines are critical for the H-1Bs, particularly because they cap in the lottery. And there is a lot of work that needs to be done before this case gets filed. So the new challenges and the required documentation and the strategies that we're using to make our H-1B successful or successful as possible that I hope you can implement. Also, addressing the challenges and one of the biggest challenges is the definition of how the definition of a specialty occupation is being interpreted. Then after the H-1B, after your H-1B has been filed, what to expect, and also what to expect next in terms of what's happening in immigration today. Before I go there, some of you and I are my clients, and I thank you for being my clients, and thank you also for partnering with us under this difficult time to create the best cases that we have for you. And some of you know that I am an immigrant myself, and that's part of the reason why I do what I do. And truly, this slide that we're seeing is kind of a little summary of my life. And I almost have to look at it on a fairly regular basis to keep me grounded and positive through the changes that we're going through. I was born in Cuba, and that's me on the top left-hand corner. Immigrated to Canada first, became a Canadian citizen, and then immigrated to the United States and became a U.S. citizen. That's me actually when I became a U.S. citizen. That's my certificate in my hand, and obviously the big U.S. flag at the back, and a big smile because I was coming from a very bureaucratic regime where I was born out in Cuba to a place where I came to because of freedom and because I thought the bureaucracy was not going to be as bad as it is today, at least in terms of immigration. And then that's me on the left bottom corner after graduating from law school. And then one of my outlets is triathlons and marathons, as many of you know. And so that's me last year crossing the finish line. And through all of this processes, I've been nervous, I've had uncertainty, I've had fear. But when I overcame the challenge, I was excited, I was optimistic, I was confident. And this is kind of, I analogize this with what's happening in immigration. At this time, prior to filing this petition, there's a lot of nervousness, uncertainty, fear as to what is going to happen. We take our clients through the process and hope to successfully cross that finish line. And at the end of the day, and in fact, it has happened quite a few times this year, and I'll explain further in the presentation how or why. But we've had quite a few excited, optimistic, confident clients. And again, look forward to working with you this year to get you to cross your finish line. So what are the basics for the H-1B? Basically, there are 65,000 new H-1B petitions, plus 25,000 that are specifically designated for U.S. masters or higher. So just because a foreign national has a master's degree, that doesn't necessarily entitle them to one of these 20,000. They have to be a U.S. master's degree. So if you're one of those lucky, and then we will file your petition with designation of that says U.S. Masters. We typically put in red caps at on the cover letter, so right away the mailroom at USCIS, which is receiving thousands of petitions, is going to know that you have a U.S. Master's degree, and it will go into the U.S. Master's pile. The benefit of those that have a U.S. Master's degree is that they will go into the first lottery, and if they're not selected there, then their files will go into the second lottery, the one that includes the 65,000. And so you, in some way, you have a double dip at the lottery. And some clients that were not awarded the cap last year, and there were bachelor's degree students, I have certainly recommended to them, if possible, to continue pursuing their studies and aim for a U.S. Master's, but not just a general U.S. Master's, but actually look and see based on their interest and background and aim for a STEM U.S. Master's degree, because that also has additional benefits. So that's in general what the cap is all about. Specialty occupation under the definition basically it's an occupation or a position that requires at least a bachelor's degree, and that bachelor's degree cannot be a general bachelor's degree. It has to be in a specific field, and this became an issue last year, and in fact several petitions were denied because of the interpretation that USCIS took relating to the specific field. For example, if I put now a bachelor's degree in engineering, USCIS is looking at that as that is too broad. That is not specific enough. So we're partnering with our clients to define that engineering field even more narrowly. So is it a chemical engineering? Is it an electrical engineering? Is it a mechanical engineering, or closely related? So that's how specific and how picky I would almost say USCIS was last year with some of the filing. And then the timeline. As I said before, the timeline is very critical. Right now, as I'm speaking to you, obviously we're not February, but we started in January, and some of our clients that are on the call now that January we started reaching out to all of the clients that we knew wanted to file an H-1B this year, so that we got a list of all of those that candidates and employees that would be looked at for potential sponsorship, and we started working with them in the timeline as to what needed to happen next. Now in February, we're working with all of them in creating a job description. Not creating a job description; they all have a job description, but creating a job description that is that responds to what USCIS would like to see or have told us that they would like to see in the job descriptions. And again, I'll talk a little bit more about that. And the job description really pretty much is the basic of where everything else derives from. And that job description, under today's interpretation, cannot just be a general job description. It has to tie in what the knowledge, the special knowledge that the foreign national has, that he or she has acquired through their bachelor's or master's degree education. How is that applicable to the position that they're engaging in? And why is it that their job duties are so unique and complex that it requires someone with at least a bachelor's degree? So that's what we're doing through February. And then obviously by March, our goal is to have all the petitions ready to be filed. The LCAs, that's the labor condition application, that needs to be filed prior to April 1st. And in fact, it has to be filed at least, and we're giving ourselves at least 2 weeks before, if not more, before we file the LCAs. I've been doing this now for over 10 years,
And through the years, we have learned as to the various glitches and things that happen when every employer in the nation that has an H-1B petition tries to file an LCA. And I can tell you from our own experience, my amazing immigration specialist last year, I think, said to me, Giselle, I think I'm just going to wait until midnight to file this LCA because there was no way that she could get online during the work hours, Eastern Standard Time, to file. Every time she tried, the lines were just busy. So sure enough, she tried, I don't know if it was midnight, but it was 11 o'clock or 10 o'clock in the evening, and that's when our LCAs were able to be filed. So again, waiting to the last minute is not a good idea. Being very proactive as much as you can is critical. And another reason why that is very, very critical is things are going to happen just before you file. And you're not going to have control over that because you just don't know. For example, last year, about, I want to say 2 days before the first day of filing, when everybody had their petitions ready to go, you had to. USCIS released a memo basically saying that certain computer-related occupations were not going to be considered in general as specialty occupations. So that's how we began the H-1B season last year. And who knows what memo they have in mind for this year. But again, if you wait until the last minute to start preparing your filings, you're just going to have a very difficult time. The other thing that happened last year that also created and had us all shifting strategy was that USCIS decided that they were going to cancel premium processing. And many of you that are online that filed last year know that they canceled premium processing all the way from April until October. So there was no way to premium process a petition even if you needed to. So again, all of those things, and who knows what is going to happen this year, but the timing and the being proactive is just critical. And just so that you know, many times employers don't know that we file in April, but really the H-1B status, work status doesn't begin until October 1st. So that's something else to consider in the process. So I get this question a lot. In this year, again, we're predicting that a lottery will happen. My prediction, and hopefully I'm right, because that means that a lot of our clients will get their H-1Bs. But I believe, just considering how difficult and how much anxiety, how much uncertainty there was last year, that many companies that just file to file, and sadly there are companies that do that, will not take a chance of filing this year, and that will allow open, I guess, the opportunities for those companies that, and I'm proud to say I represent many of those employers that have 3, 4, 5 foreign nationals that are adding value and diversity and innovation and hard work and determination to the workforce that have very unique skills, and we're fighting to get them on an H-1B visa so that they can continue to contribute to our country. So if more H-1B petitions are received than visas are available, so that would be more than 85,000, a lottery will take place. The lottery is computer generated. I've asked a lot, what can I do to increase my chances? And at this point, not a lot, except for make sure that your filing is as well documented as possible. And again, we're going to talk about what that means. That it's filed completely and timely, and that's pretty much as much as you can do right now. When it's received by USCIS, they will pretty much assign a number to your package. It will go through a computer-generated random lottery, and that's pretty much how the H-1Bs are awarded. And it's sad that in a country like ours, we're dependent on a lottery to give job opportunities to people that deserve it. That is the process we have today. I also get asked a lot, is what if I pay for payment processing? Would that increase my chances? And the answer to that is not. It will not increase your chances of being selected. Premium process has its time and its place and its role, I guess. And I counsel every client, and it's very, very, very factor specific as to really under today's environment, whether to use premium process or not. So I strongly recommend that you ask your attorney, based on your facts and your case, whether premium process is something that they would recommend for you. In general, for many of my cases, we're not premium processing. And again, we've made very fact-specific decisions as to why not to do that. Now, for the past 5 years, a lottery has been conducted, and I want to do a little test here, and all of you should have a Q&A chat box at the top, and I would like to do a little test here. And so let me know, and you can answer on the chat. And what I'm going to do, actually, some of you know that I wrote a book that's called Beyond the H-1B. It's on Amazon right now. But I'm going to raffle a few of those books today for those of you that participate. So here's how many petitions the USCIS received, and I'm going to give you the answers. Hopefully it's not going to reveal all the answers as I do this. I think they do. Hold on. Let me back up here. Hopefully you didn't see that. So who can tell me, and again, you can put it in the chat or the Q&A box. The closest that gives me the answer gets the first H-1B book. How many number of H-1B petitions the USCIS received last year? So 2017. So the first person that sent me an answer in the Q&A. Oh my God, someone got it. Like, okay, yeah, actually, ooh. You guys are on it. I have actually. Oh, I wish. I want to keep your privacy, but it's very interesting. But I have to tell you, 3 people gave me the right answer. So all 3 of you will get my book, and the other ones were pretty close. So kudos to you. One was actually off by one digit, so maybe we'll see. But thank you for playing with me. Yeah. So here are the answers for the last few years, and I also on the Q&A I've been asked how many people usually apply through the master's pool, any rough numbers, and really it has varied throughout the years. And I would say the number that sticks in my head is 50,000, but that might have been 2016. I tell you though, in general, my U.S. Masters, as I look back through the numbers and through the petitions that we have filed, most of my U.S. Masters have gotten the H-1Bs. Again, don't take this as there's no rule here, but as general practice, my U.S. Masters have gotten the H-1Bs. So for those of you that are wondering, it's certainly an advantage. So, and again, thanks for participating. I'm going to have a few more questions for you as we go through, but for now, kudos to the ones that are going to get the H-1B book. All right. So, what are the current challenges in there's a lot, but I kind of narrowed it down to this 4, and I'm going to go through it fairly quickly. One is the lottery, whether you're selected or rejected. If you don't get past that, the rest really it's a non-issue for now. Then the next bigger issue that hasn't been a big issue in the past, but it is now, is proving the specialty occupation, which is sad that we have to show to the government that an engineer is a specialty occupation or that an architect is a specialty occupation, but that is what we're having to do. Then the other issue that came for the first time ever last year was this wage level. foreign nationals that are wage, so there's 4 levels, so that's why we have 4 rolled dollars there, 1, 2, 3, 4. Those that are at wage level 1, USCIS is also having an issue with that and basically saying, well, if you're an entry level, you probably are not a specialty occupation, which is totally crazy. Everyone that I know after they graduate from school, they're at an entry-level position. So last year, our approach to that, which appeared to have been successful, basically we argue, the wage level it has no determination, and that basically is what the law says. Whether you're level 1 or 5 or 4 actually does not determine whether you have a specialty occupation. That's the wage level issue is a Department of Labor issue, not a USCIS issue. So really, even though you're questioning this, you should not. But by the way, we don't feel that this is your area of expertise or that you should be asking us about this, but the law provides that entry-level positions are specialty occupations, and this is why, and we provided documentation based on the cases that we were filing. And again, I think if you remember, at the beginning of the presentation, I said to you that at the beginning of this year, we had some good news among many of the negative news that we had, and pretty much all of the petitions that we filed last year, our H-1Bs that were RFE'd, and we did not premium process them, again, based on the facts of the case and after a lot of communications with the clients and making decisions as to whether to do it or not. We just waited, and we could wait because the foreign nationals were a STEM occupation, so they were able to get the EAD extension, or they were bachelor's degree and they were able to get CPT. So there were ways to keep them employed or in the United States. So there was no need to premium process the petition, so we just waited. And at the beginning of the year, I've been getting H-1B approvals, and for the first time ever also, typically by October, all of the H-1B petitions have been adjudicated, but not this year. But now we have, and I'm pretty much right now, I think I want to say about 2 weeks ago, we got the last H-1B approval from last year's lottery. So that's where we are. And then that brings me to the last little icon here, the timing and the delays. There's unbelievable how long this is taking. So cases that we filed last year in April, it's almost taken a whole year for those H-1Bs to be processed. Never, never, never in the history of USCIS has that happened. So be on the, know that delays are the new norm. All right, so how are we addressing these challenges? Well, first, we're having strategic meetings with all of our clients when we begin the case, and we go through many of the things that we're talking about. What is the title? What is what are the job duties? How can we relate those job duties to the education that the foreign national has? How can we relate those job duties to the complexity of our employer's operations? Tie it all together. And what is the wage, and what is the wage going to be? And this is a question that I started asking this year. What is the wage going to be? Not now, but what is the wage going to be like in October? Because really, that's when it matters. So, and after having this conversation, sometimes we were like, oh my gosh, they're not level wage 1 anymore. They're wage 2, because by October, that's what they're going to be. So those are the kind of conversations that need to happen. Definitely extra documentation and information. I know many foreign nationals that I'm talking to have said to me, well, I just talked to my friend, and these are new H-1Bs, and they've never had to do this because I'm asking them to really beef up what they're doing, and I'm asking them to take a project or 2 or 3 that they're involved in and show how their skills, their unique knowledge is contributing to that work. And literally, that's one of the factors that made our H-1Bs approvable last year. So yeah, extra work, extra documentation, extra information. It's all part of the strategy. Again, we talked about the filing of the LCA with plenty of time. We've talked about the extensive and documentations in the form. We've talked about staying alert for changes. They are going to happen. They happened last year at the last minute, so leave yourself some room to be flexible. Final review and signatures with plenty of time, and then, of course, file and track the petition and keep fingers crossed for an approval. I'm just going to take you in general what this looked like for us last year, so you get an idea as to what we're getting into. And this is a typical H-1B case, new cap case, an engineer that is in the United States on an F-1 visa with a U.S. master's degree in electrical engineering, and basically we're moving them to an H-1 as an electrical engineer. So last year, yay, and this is actually one of our cases, this is one of the H-1Bs that was selected, so we were all thrilled. And in years past, this has been it. I mean, we're ready to launch fireworks when we got the notice of receipt, because that was pretty much a sign that, the case was going to be adjudicated, was going to be approved for national, was going to move on to an October 1st H-1B worker status, and everybody was happy. But last year, for the first time, that was not the end. We started to see requests for additional evidence. And actually, so here's your next chance to get another H-1B book on their My Little Raffle. How many, and just use the Q&A box, how many requests for additional evidence did USCIS issue last year? 50% was the answer. So those of you that got it right, you are in the lottery for an H-1B book. Yes, yeah. So thank you again. So 50%. That's and I'll give you the answer for the prior year. So for the 2016, the RFE rate was 20%. Huge difference in what we're seeing. So anyway, so we got our request for additional evidence, like 50% of the other filers did. And again, note that, there's many people that are applying for H-1B visas, not just they're new visas, but they're people that are, new grads from a master's degree or from a bachelor's degree. But there are also people that have been in the United States and they're on a TN, or they may be on an L-1B, or they might be on they may be abroad, and therefore, their employer is sponsoring for an H-1B visa. So and those that had a very solid, and some of them, again, were not engineers or architects. They might have been lawyers or physicians. So some of those were not the target of this H-1B, of this RFEs. So anyway, we got our RFE. The main things that my RFEs dealt with was a specialty occupation and wages. So why those require someone with a level 1 wage to get an H-1B, and why is an engineer a specialty occupation. So here was our success strategy, and again, this is a true case. Look at the size of that RFE response. So our initial filing was probably, and it was very well documented, but it was about half of that. And the RFE response, which we really went at it with everything we had. There was 4 prongs to prove a specialty occupation, and we used 3 of them strategically on every response, because what was happening is, and I was tracking what was happening across the nation with other petitions and what USCIS interpretation was. And if you really reply to an RFE with 1 response, for example, it is a specialty occupation because the handbook, the Occupational Outlook handbook says so, and USCIS decided, well, no, I don't agree, then you're done. So we really use all 3 prongs. And those prongs, the gist of our responses were the foreign national is part of a very specialized team, and that's why the org chart that you see up at the top. The team encompasses other professionals, and those could be engineers, architects, project managers, business leaders, whatever it was. So we provided them with org charts, provided them with the background information of the other team members, show how the foreign national was a component of that successful project or team, provided lots of pictures and interactive evidence of the foreign national working on a particular project, mocks of the work that they were doing, pictures of the design if that's what it was involved. It again made it very, very personal, very hands-on, that a USCIS adjudicator could look at these files and say, oh my gosh, I see how they're contributing to the U.S. economy. And again, our approach, at least for last year, was successful, and that is the same approach, at least that we're taking for this year, to hopefully get us there. Was an important piece of the success strategy is to keep calm and just wait. When USCIS opened the premium processing files, ability to premium process last year, as I said, they had discontinued premium processing for all H-1Bs, not just the new ones, and they opened it again in October. We were so tempted to just go ahead and say, okay, and again, talk to our employers and decided on a case-by-case strategy as to what to do. Should we premium process or not? And we did not premium process one petition at that point, again, for various reasons in every case. But I am happy that we did, because what happened is that many of the, and again, I know this because me and most immigration attorneys around the nation were following what was happening through our organization and how, people were posting on our forums what was happening and the responses that they were getting to the premium processing and all that kind of stuff. And to my amazement, many of the petitions that were premium processed initially when the premium processing filing opened, what happened is those petitions got a second set of RFE. So not only do you have to respond to the first one, now you had to respond to another one. And what happened is the adjudicators, for them, this was an escape. They just didn't have 15 days to adjudicate the petition, so they said, okay, well, we'll issue an RFE and let them deal with it. So it was it was a very difficult time. Lots of anxiety in many ways, very frustrating. And really the strategy was just to keep calm, stay informed, and my clients know that we're going to be, we have in the past, and we will continue this year to send, not reminders, but updates. I have a specific group with all of our H-1B petitions and all of our H-1B employers and the foreign nationals that we're filing for. We're sending updates as to, what's happening. The filing began. Your petition was filed. Now we know how many petitions were received, and this is the number. And, the lottery has begun. The lottery has been completed, and all that kind of stuff. And just staying informed and waiting was critical, and again, will continue to be critical. So here, and actually you can see this is, again, one of ours. At this year, notice date, 1/23/2018, one of our H-1B petitions that we filed last year, 4/11/2017, was approved. And again, since then, a few more have come. But again, it took a lot of patience, a lot of waiting, a lot of a strategy. So some of you that are my clients, employers, and foreign nationals that are on the line listening to this, thank you for staying the course with us and working as a partner and as a team to get some of these petitions approved. And then, unfortunately, some of them were not approved. Some cases there was even after a request for additional evidence and after a response, USCIS had decided, nope, we don't think it's a specialty occupation, or we think that the specialty occupation that you picked is too broad. Like, for example, the engineer situation is not specific enough. So again, we are learning as we go through this. It's unprecedented times. We don't have anything to. We're just learning and strategizing as we go through it. And the best that we can do for you is really to work with you as a partner, stay on top of what is being provided to us, and do the best we can with the information that we're receiving to make your petitions the best they can be. At the end of the day, some are not going to get the H-1B, either because the RFE, the case was denied for some reason or another. And again, there's no really, if you look at some of those decisions, there is no true justification for the reasons they're giving. But the appeal is such a fruitless battle that it's really not worth it. So what happens if the case is not you do not get the H-1B? So if you do not get the H-1B, there is many other options that we're looking at, and again on a case-by-case basis, including an O1, a STEM OPT, F1 CPT, H-1B concurrent employment, and there is a whole variety here, and some of you that are going to get the book, I have a chapter in each one of them. I have a question, and I'm trying to answer a lot of these questions as I get them because this is for you, and I'm not going to answer case-specific questions because there's so much involved, but general questions I will. So this one, if an applicant is not employed at a popular company, do they have a higher chance of receiving an RFE? And really, not necessarily. At least the trend that I've seen, it's not necessarily let me back up, because who your employer is does have something to do with how the petition is received. So larger employers, and larger doesn't have to be billion, it doesn't have to be the Microsoft or the Googles of the world, but larger established employers, and that could be more than 100 workers or something like that, have a better chance in the eyes of USCIS. Because again, they see the H-1B worker as someone that is coming in, and that's how we have to position this case, is someone that is coming in to strengthen the team of workers. And that's, again, why our success strategy, I believe, last year was successful, because we were able to position these petitions, and thankfully, my employers, that's the kind of clients, employers that we work with. I don't have one petition that I file that is just one foreign national for an H-1B that is the only employee of the company, and nothing wrong with that. There might be a perfect situation for that. But in my cases, we are typically representing employers that have a team of workers, and the foreign national is one of the members of that team, a very key component of the member of that team, because they bring, again, unique skills, unique innovation to the team, and basically that's how we present it to USCIS. And that, in a way, is how USCIS sees the H-1B position, at least today. So it gives more credence and credibility in the eyes of USCIS. Now, I have also smaller employers that don't have 100 workers, and they have 10. And those petitions, we have to work a little harder with our employers and their foreign nationals to make sure that we really, really emphasize how important that foreign national is and why their education and their unique skills are so important to make whatever the project, whatever the business is, successful. And that's how we approach those cases. Okay, so there are options beyond the H-1B, and So this one is something that I'm going to send to everyone that is on the call today as a gift to you for participating. Thank you for being there. And it's really, it's kind of a summary of the H-1Bs are gone. What else? What else is there for me to look at? If you are one of our employers and foreign nationals that we work with, obviously we're going to be exploring this with you on a one-on-one if we have to go there. But for others, again, this is just a resource that you can start looking at, and just in case, the H-1B does not work out for you. So here's the cover of the Beyond the H-1B. Again, some of you will get this in the mail, and thank you. Now, the H-1B has been filed. Now what? Again, being patient and just being alert and educated as to what is going on is going to be critical. Many of you know, again, that I'm a runner, so you can see not everything. Do not go on the internet and start looking as to what's happening to this friend and the other friend, because there is so much misinformation out there. It is very sad, and it only creates more anxiety. So be careful as to where you get your information from. Again, what is important to know after the H-1B has been filed is one, was it receipted? And you won't know that. Typically, again, what happens is the lottery opens for the first 5 days of April. So I believe it's going to be from 2nd to 6th. Then it closes, and then that's it. No more H-1Bs can be filed if the 85,000 have been received. Then it is taking USCIS about a week to run the lottery, and then we typically know that the lottery took place. And then the receipts are going to start being issued. Now, so here's where premium process has some little advantage. If you really, really, really need to know, if you premium process your case, then rather than waiting until, who knows, June, July, August as to whether your petition has been picked or not, if you premium processed your case and your case was selected, then you would be one of the first ones to know if your case was picked. Again, because they have to adjudicate 85,000 petitions and they're overwhelmed, it is not unusual to get an RFE with that premium process petition. So again, unless it's necessary and there are cases when you need to do it, at this point I would not premium process most H-1Bs. So wait until the lottery has happened. The receipts are going to start being issued. Again, our clients will get their feed from us, basically saying this is what's happening. And then in the past, except for last year, all petitions were adjudicated by October 1st. And that has been in the past the target for USCIS. Again, we'll see what this year brings. I just told you up until the beginning of this year, we were getting receipts and approvals from last year's H-1Bs. So we'll kind of see what this year brings in terms of H-1B. This is something also, this live is very important for many of you that are on OPT, and I get this question a lot, what does this mean? So again, April, and this year it's going to be April 2nd to April 6th. That's the H-1B petition filing period. If you're an OPT EAD, so you're working, and you have your EAD and your petition is filed, and let's say your OPT EAD ends April 20th. Basically what that does is that EAD is pretty much automatically extended until October 1st. Unless, you know before October 1st that your petition has not been filed. It is very, very important for those of you that are students to stay in contact with your student advisor and let them know what is happening with your petition. So, for example, wow, I got a notice from my employer or from my attorney that my petition has been picked for the H-1B. They should be logging that into your service record, and they should be keeping track because they need to keep your service record updated so that all those systems supposedly communicate with each other. If your petition was approved, you need to let your student advisor know that your petition was approved so they can also update your service. And again, if everything works the way it's supposed to work, your petition is picked, you know sometime in June, July that you were picked, and the petition was adjudicated successfully and approved before October 1st, then you will continue to work on your OPT or your EAD until October 1st, and then October 1st you transfer to your H-1B status, which is typically good for 3 years. Here, we're coming to the end of our time, so I want to make sure. The future. So on a maybe positive note, we'll see. I'm staying in touch with everything that is happening in Washington. I was on a conference call just a few days ago, again, talking about the H-1B and what to expect and what's coming. We haven't seen any memos relating to H-1B, and so what's going on. So in general, more restricted eligibility, just like we've talked about, even though there hasn't been a memo about it, it's just what we're seeing. They're looking at immigration almost in phases. At least this is what the representative from Washington said. So phase one, what is in the burner right now in Washington as we speak, there's 4 items of immigration that are taking the majority of the discussion, and that is DACA, as probably you all know. It's in the news almost every day. DACA is so the four prongs of the stool, I guess, or the 4 legs of the stool for immigration in Washington today are DACA, border security, eliminating the diversity visa. There's 50,000 of those out there, and restricting significantly the family-based immigration. We don't know what at the end of the day what's that's going to look like, but the Washington spokesman talked about phase one and those 4 legs of the stool. So that's what is in the burner now. So we all said, what about the H-1Bs? And he said, well, you know, the H-1B is always there, but it's not necessarily, you know, right now, like I said, this is phase one, and that's what we're looking at. The phase two, whatever that starts, the prongs of that F2 leg or stool are probably going to be changes to the OPT and the OPT STEM program, potential pre-registration for the H-1B cap lottery, and yes, we're looking at all of these things for next year. Changes for the specialty occupation, the definition of what is a specialty occupation, and maybe someday more H-1B visas. We'll see if that rings true. We certainly have had more H-1B visas in the past, and it's only really the last 5 years that we've had this issue with H-1B visas. So we'll see what that brings. I started with crossing that finish line and what it meant for me throughout my life. To cross that finish line and the anxiety and the challenges and what that meant, and how making it through all those challenges with help, with support, with partnerships, bring happiness, peace of mind, opportunity, relief, and that is really what I'm wishing to all of you on the call today. I believe a big part of for you, our employers, our foreign nationals, bringing them happiness and peace of mind, opportunities, relief. It's also being educated as to what is going on. So kudos to all of you for taking the first step, or another step in the process of being educated and preparing and knowing what to expect. So I don't have any new questions on the queue here. But if you have any questions, I've been answering them in general as I'm getting them on the queue, not necessarily reading them, but just incorporating them into my speech or my talk. But if you have any other questions in general that I have not addressed, this is your chance. We have a few more minutes left. So I'm going to give you all a few minutes there. Okay, going once, going twice. All right. If you have not, if I didn't answer your question, certainly if you're a client of ours, hopefully this has been helpful to you, and you may have learned some things through the presentation that we have not talked about, and we certainly want to make sure that we cover those. So reach out to us, let us know. Again, thank you for being on the call, and we'll keep you updated. Take care.